Look at us, live on Rumble as scheduled.
Holy cow. The technological marvels of this universe never cease to amaze me, along with getting out of bed every morning. Good morning, everybody. It's Tuesday, I guess, and you're back. And we're back. We're all back. It's Law and Legitimacy. Welcome. Lots to talk about today. I'm going to kind of go out on a limb today and suggest that John Lauro's days as Trump's lead counsel in the January 6th case are numbered. And why, you say? And I think it's a matter of messaging. I don't think he and the client are on one page. And the result is Trump is blowing the opportunity that he has to make his case to the public. What am I referring to? Two pieces startled me yesterday. One on Apple News. That Lauro is apparently distancing himself in public comments from the attack that Trump lodged on the trial judge, where Trump called for her recusal as a partisan hack and so on and so forth. And the lawyer's like, well, you know, in a normal case, we wouldn't want our clients talking about that, but this isn't a normal case, but I promise that I'm going to try this case civilly and responsibly and yada, yada, yada. And, you know, when Trump has an opportunity to make his case to the public, he needs to make his case to the public. Someone needs to make it to the public. But the story is now becoming Donald Perry's, his lawyer does a counter thrust. Donald Perry's, his lawyer does a counter thrust. And Lauro can't have it both ways. You know, one of the things you learn in a high profile case is that you are not the message. And one of the temptations for young lawyers, and Lauro's no kid, he's 61, but one of the temptations in a high profile case is to think that they're all there about you. And the fact of the matter is you're fungible. They're there for your client or your issue, and you are there to represent the client or the issue. And so you have two choices. Either craft a message that is consistent with the clients and that has the client's approval, or shut up and do nothing. And Lauro appears to be having it both ways. I read up on him last night because I thought he was behaving like a guy who'd never been hit by lightning before and expected him to be far younger. But at 61, he's been around the block, or at least should have been. So this inconsistent messaging, Trump saying one thing, the lawyer deflecting, backpedaling, and seemingly serving his own interest to say to everybody, what a good and responsible boy am I. I'll do my best with my madman's clients, madman client is blunting Trump's message at a time where he shouldn't be engaged in pre-litigation footwork, but he should be pushing this case to trial as quickly as possible in order to bring the message that he wants to bring to the American people. As we've said before, this trial is a potential campaign event. The second thing that struck me in the media yesterday involving Lauro was a discussion he had on NBC News, I think on Meet the Press, if that's the host of that show, where he was asserting a position that may be right and may be an interesting op-ed proposition, maybe even a good law review article, but is counterintuitive and once again shows Lauro at cross purposes with his clients. What am I referring to? Well, you know, just because Trump may have violated the Constitution, that doesn't make it a crime. That's a sort of counterintuitive statement that kind of makes you shake your head. You see,
what does the average person make of that statement? I guess that's, you know, lawyers kind of sometimes forget that they're speaking in nuances of the law that don't necessarily fall on the average civilian with
I get it.
Real efficacy, right?
No, I mean, I get it. The Constitution is the fundamental law of the land. And if Trump violated the Constitution, it's not a point that Lauro is conceding. It might not meet the technical requirements of theft of fraud within the theft of honest services or within the fraud counts. And, you know, I good luck with that argument, John. But the real question is, why are you making it? You get the impression that Trump was arraigned early or presented in court late last week, and that Lauro hasn't stopped, and he's cashed in on as many media opportunities as he possibly can. The result has been that we don't have any greater clarity on the position that Trump intends to take at trial. What we have is confusion about who's in charge of the public face of the defense and what the messaging is going to be and what the themes are. So Lauro and Trump will either get it straight or Lauro will get a new assignment, presumably with another client, and Trump will change counsel.
Well, I've obviously got this tweet on the screen here. This was from 4:10 in the afternoon, and your prediction was that that he would be out within a week. Do you stand by that, or some redemptive?
Well, I mean, I'm not going to bet the franchise on it, but it seems to me that there's been a lot of inconsistent messaging, and Trump has come out hard as regards the judge, and Lauro's immediately backpedaling and distancing himself from his client. Trump has come out hard with respect to other claims, and Trump is explaining Trump away. He's not aggressively advancing the litigation. And now the storyline seems to be Trump versus his lawyer versus
Rather
Trump.
than,
yeah. And once that happens, it's dead. So, yeah, I guess I do stand by it. I mean, there'll either be a quick change of course and an attitude readjustment, or Trump is going to have to find himself new counsel, or tantalizingly represent himself pro se. That would, people have the right to represent themselves in a criminal case. It's the Sixth Amendment right. The lead case is United States versus Ferretta, F-R-E-T-T-A. It might not be for the United States versus Ferretta, but it's the Ferretta decision. I don't think Trump will do that.
Those court transcripts would be like in the MoMA immediately upon availability. Good Lord.
And this raises the next question about why is the Wall Street Journal criticizing the Democrats for wanting a public trial? The Journal takes the position in an editorial that they want this to be the O.J. Simpson trial. The O.J. Simpson trial didn't become the O.J. Simpson trial because it was televised. It became the O.J. Simpson trial because we had a nitwit, a halfwit at the bench named Lance Ito, who was doing pretty much what John Lauro is doing, falling in love with the camera's glare. If you can't forget about a camera in the courtroom, then don't be in a courtroom with a camera. That's the motto. But it seems to me that, the Journal's position, that is that the Democrats want to make this into the defining event of the 2024 campaign, presidential campaign, is undoubtedly true. And it's going to be whether it's televised or not. And so we've said it before, said it today, we'll say it again. Trump needs to rise to the challenge and make this a campaign event himself and not run from it. As far as the televisation of the trial is concerned, or televising of the trial, I disagree with the Journal. I don't know where you're at, Mike, but my view is this is compelling. The people have a right to know. I'd like to be able to evaluate the case myself. I'm not sure how much of it I'd actually get to watch, given my other commitments, but I'd like to decide how much of it I watch, rather than have news reporters tell me how much of it they think is important.
Well, the news fare that would flow from a televised trial is something that I've yet to wrap my head around. We know that some of the more high profile, there's this new sort of subgenre of live streaming that developed around the more recent cases with Johnny Depp and Amber Heard. There was the development around, what was the couple that went on their little their RV vacation, and there was murder charges, missing bodies, that kind of stuff. I can't remember the names right now.
Yeah.
Anyway, what we saw is that there was a wellspring of independent live streamers that would essentially tune in to whatever broadcast channel was airing Gabby Petito, thank you, photography, would live stream that, and particularly attorneys. They would, I think Viva Frey and Robert Barnes did a lot of that. I think that if for whatever reason we did get a televised trial in Trump, that would make whatever was going down with Johnny Depp and Amber Heard in the Petito case look like nothing ever happened. I mean, just imagine on both sides the independent law tubers, as it were, that would emerge. I think that this article points out that I think that Schiff argues that the transparency would provide legitimacy to the eventual outcome of the trial, and that Democrats should lean into the fact that Trump supporters might accept a guilty verdict if they're able to see it happen. I don't know that I buy that, right?
Yeah, I don't know that I buy that either.
I don't know that I buy that. I think that the televised portion should be for the sake of transparency, but should not be for any other purpose, right? We shouldn't be linking that to some assumption that that will provide legitimacy to the outcome, especially with the likes of Trump under the microscope. We know now more than ever that his base is as hardened and unmoving as you can imagine. So it's not that there's going to be any. I don't know that putting that trial on TV is going to have any impact on the fervor or the support or whatever you would like to qualify his base.
Yeah, I just think it'd be a good education in civics for the American people. I remember as a young guy, back before your parents probably even knew one another, Mike, watching the Watergate hearings, or at least some of them, and was transfixed by Sam Ervin's, holding the United States Constitution and the notion that the president could be accountable to the people in this oversight capacity. So we're all in favor of televising the trial. Let's get it done, because we want the opportunity to drink craft beer and beverages from AB Bev. Maybe. Mike, what's going on with AB Bev?
So news broke yesterday afternoon that Tilray, and Tilray is a Canadian cannabis company, Norm. So that's really important. And this isn't Tilray's first foray into the beverage alcohol market. Tilray acquired, as sort of its first move several years ago, Sweetwater Brewing out of Atlanta, Georgia. And Sweetwater Brewing is a namesake brewery for a lot of people. They've got, popular brands that you see on grocery store shelves, and they've always leaned into the cannabis-inspired theme, sort of taking advantage of the overlap between hops and cannabis because they are sister plants. And because of that, the resins and then the sort of floral aromas and just the general culture and brands around cannabis gave something to Sweetwater that it wouldn't otherwise have. They were able to put names on their beers like Sweetwater 420 and Mango Kush Wheat Ale and certain things like that. And I know a little bit more about that than I care to admit on stream right now. But
yeah, Mango Kush Sweet Ale. I mean, honey, can you go to the store and pick up some Mango Kush Sweet Ale? No.
Well, so Tilray, I have here on the screen, they announced an agreement with AB InBev, who is the maker of Budweiser and Bud Light, Natural Light, the company that has been under the microscope for the past, 4 or 5 months in response to the Dylan Mulvaney partnership and the Instagram posts, what have you, subject of the complaint that we analyzed a couple of weeks ago that was initiated by Ted Cruz with the Craft Brewers Alliance. And what they've done here, and I think I've said before, that AB InBev is much more than the sort of premium beer brands that I just listed. They have a portfolio, or they had a portfolio of, I believe, 14 craft breweries. And what they did in the years leading up to now was, as craft beer was booming, You're My Hero says, I like beer flavored beer. Hear. What AB InBev did, it like Constellation, the owner of Modelo and Corona, and what Miller Coors did with the likes of 10th and Blake Brewery and Blue Moon, as you might recognize it on store shelves, is they started playing in the space of craft for a number of reasons, but primarily because craft became sort of death by cuts in terms of market share. Right. There was no one craft brewery that was offending the sensibilities of shareholders at AB or Miller Coors or wherever. But when you were on pace to have 10,000 individual breweries in the United States, and that would have been an increase of multifold increase over less than a decade period, you can start to understand where consumers maybe aren't vying. You're not necessarily losing market share on store shelves, although they were, or having to compete harder. But you're also losing people walking into stores to find your beer, right? Instead, they're going to breweries. They're going to places, third-party tap rooms and that kind of thing. And so what we saw is AB InBev develop what's called I think the high end is their craft beer collective of investments. So they purchased the likes of Breckenridge Brewery out of Colorado, the likes of Blue Point out of Maine, I believe. Out of Asheville, they bought Wicked Weed Brewing. So you can start to Elysian Brewing in 2015 out of, I believe, Oregon. And if I've messed up any of those dates, please, somebody, you can correct me. But what they were doing at the time is basically investing in twofold, right? They saw better margins in craft taking over, and then also hedging their bets on their mainstay brands, the Bud Lights, the AB or the Budweisers, and that kind of stuff, to shore up sort of, I guess, loss of perceived market share. but they were doing so, Norm, at insane valuations. I think the worst case of a valuation that I've ever seen is when Constellation Brands bought a brewery out of San Diego, and I'll remember the name of that brewery in just a moment, for $1 billion with a B.
Wow.
And then later sold that same brand for like maybe, I don't know, 8 digits in the millions, low millions after doing that just a few short years later. Ballast Point is the name. And so now looking at what this is, right? We've got 8 brands that are subject to this agreement. And what's great about having publicly traded companies transacting together is that you can find what's known as an 8K or a required filing that companies are required to make when there's something that affects the value of their stock. So I'm going to put that on the screen real quick. This is what you can find on the sec.gov's website. In the archives, there's a system called Edgar. And anytime a company has to do quarterly filings or annual reports, or there's any sort of special, in this case, an 8K, some sort of special filing that needs to be made, you can go on there and you can see. And what's rare is in the craft beer spaces, we don't always get to know what the purchase price of these brands and these acquisitions ultimately are. Here we know that AB InBev is accepting $85 million in cash for 8 of its brands, including Shock Top, including Blue Point, and I believe a couple more. And what's interesting, I brought up the cannabis-inspired stuff earlier. At least 3 of these breweries, 4 actually, are in states, 5 actually, now that I'm thinking about it, are in states with legalized recreational marijuana use: Washington, Oregon, Colorado, New York. So I'm interested to see what happens on the other side of this, because these brands in and of themselves, think Shock Top, they're not that impressive in terms of what they may be valued now. But I am interested in why someone like Tilray would be interested in acquiring sort of flatlining brands in a market that is rapidly consolidating and going through a real in its life cycle at the moment. So I think it may have something to do with marijuana. And I'm interested to see how Tilray pushes the line in states where these breweries are situated because of their recreational legalization of marijuana, and they're tied to it in cannabis in Canada.
Is there any truth to the rumor that they're getting ready to consolidate behind Mulvaney Brew, and with an advertising logo, "One sip and you won't know your gender"?
Yeah,
when
right?
she became a he, drink Mulvaney. I don't know. Well, interesting stuff. I don't know. I don't know where it all leads. Is there any sense that they needed the cash? Of course, I guess if you're playing in that league, that's not that much money, right?
Yeah, I was going to say, this is an incredibly low valuation. So I don't know that this is a signal of AB InBev just struggling as much as it is as AB is shedding weight and consolidating around the craft brands that it maintains, right?
And I guess from the Canadian
right?
company's perspective, could you just be buying the distribution networks? Is that, or do they not need
You
help?
are. You're actually required to do so, right? So there's the real property aspect of where these breweries are, right? You're also buying the intellectual property and trademarks, those rights. So any of the beer names that may be conducive to the broader sort of Sweetwater inspired portfolio. And then you're also inheriting the distribution networks so that you will have ins with distributors around the country for products that perhaps Sweetwater needs to take better advantage of, et cetera. One thing I loved learning about, I shared this with you before we started the stream, as there's a section on the table of contents here for the 8K. And it says, let's see, I want to make sure I find it. The Labatt Agreement. So for section, I guess that's 8.13. And what we learn, I'll highlight it here. What we learn is that Shock Top is actually produced, I guess, in full at Labatt's brewery in Canada. So Shock Top is a nationwide, that was an in-house created wheat beer. They call it a Belgian white, but it's sort of a citrus wheat. And that's something that AB kind of leaned on for a long time as a hedge against Miller Coors' development of Blue Moon, right? Shock Top was supposed to be the competitor to Blue Moon. Shock Top has been in a Hindenburg flaming disaster of a competitor. So there's really little value to that. I just love seeing things like this where you don't realize that Labatt, it's producing all of its products, but it's also filling its own volume by brewing something for a stateside effort for Shock Top. So
wow,
off that.
Well, interesting developments. Let's keep an eye on it. Speaking of interesting developments, what's going on next to in Guilford County, North Carolina? Isn't that the home of a certain young man I know who happens to be speaking right now?
Yeah, that's right. I'm trying to find this this article that I shared with you. I think I've got it right here from the Carolina Journal. So mother's suit shows COVID legal battles are far from over. So here in Guilford County, the seat being here in Greensboro, North Carolina, there was a lawsuit launched in 2022 by the parents of an underage
14-year-old football player.
Yep,
yeah.
Yep. And the facts are something like this. The 14-year-old who would have been a rising freshman going into high school at Western Guilford High School was required, because this was during still sort of that phase of COVID related whatever
in 2021, right? Yeah,
right.
Yeah.
And because there was some sort of cluster outbreak of COVID, the football team gave notification to all the players that all the players were required to go get tested before they could step on the field. And they told all of the students, you can go get tested at the school on this day between this block of time. Testing is free. You will need to have a parent with you. Parental consent is required. Well, coincidentally, there was also a free vaccination clinic going on the same day during the
same location. Yeah.
Right. Same location, same block of time, and also required parental consent for vaccination. What occurred, according to the lawsuit, is that the 14-year-old was dropped off by his father, who stayed in the car. He went in, sat down, checked in, and then the school apparently, or the association that was doing it, I forget the name of the it's like Old North State Medical something.
That's right.
They attempted to phone the student's mother, and she didn't pick up, but his dad was right out in the car. And what they were attempting to do was secure consent to give him the vaccine rather than just the test. It was, they wanted to give him the vaccine. According to the complaint, they couldn't get up with her. They made no attempt to get up with the father. And then one of the people working the vaccination clinic said something to the effect of, just give it to him anyway. And that is despite the student also saying, hey, I'm only here for a test.
I don't want the vaccine.
Correct. Yeah. And so now we have, I guess, the basis for a constitutional lawsuit blooms. This was filed in the trial court here in Guilford County, and that trial court judge dismissed all 5 claims out of the court.
Let's unpack the law for a little bit for ordinary people who haven't endured the agony of law school, which some of you will in the fall. And stay tuned here; we'll tell you how to survive it. But so, what is you hear about assault and battery? Battery is an unlawful touching of a person, or an interference with their body, in a way that is unwelcome by them. And so, and giving a person a shot is obviously interfering with their person. So if a person says, I don't want the shot, and you give it to them anyhow, you have arguably committed a battery. Now, the mom, in this case, it was his stepfather, by the way, Mike, not that it matters, but it may matter in terms of who brought the suit. The mom brought a suit for a constitutional suit under North Carolina law, claiming that her liberty interest, that is her ability arising under due process of law to raise her child as she see fit, was interfered with because this shot was given. And the trial court made a very unusual decision. It concluded that because there was a state law tort available, a battery, and the mom hadn't sued on behalf of her son for battery, but had sued on behalf of her own liberty interest, therefore the suit should be dismissed. I leave it to North Carolina lawyers to tell me how crazy that sounds. I can tell you from a distance, it makes no sense at all. There is a maxim that judges use when deciding issues on appeal, and that is, you don't decide a constitutional issue unless you have to, because constitutions are, after all, the fundamental law of the land, and they have broad application beyond the principles in them have broad application beyond the suit at issue. In this case, the appellate court required that rule of judicial judicial review, as it were, to the facts here and said, well, we're not going to reach the constitutional claim because she had an available state law tort. An appeal has been filed. I read the brief this morning. It's a perfunctory piece of work. I mean, 16 or 17 substantive pages cover 5 issues. But among the issues for the North Carolina appellate court will be whether that was erroneous reasoning. And I certainly hope it was, because the facts in and of themselves are shocking. First, the young man was summoned to the school to take a test. When he was there, something else was done to him without his consent, without his parents' consent, and over his objection. This was the functional equivalent of an assault and a battery, an invasion of his person without his consent by people cloaked under the authority of the state. Now, one of the other reasons that the judge dismissed the suit is he says, the medical clinic wasn't a state actor. Well, one could argue that. And I think on a motion to dismiss, it was probably wrong to conclude that it wasn't.
We should revisit that, Norm, if we can, just the procedural mechanism of a 12B6 and what that means in terms of the burden that the moving party bears in order to prevail, and how rare it would be in a case where there are 5 claims for relief under these facts for a moving party to prevail as a matter of law, right? Not as a matter of fact, but as a matter of law. The trial court said that in viewing all of the facts available to us in the light most favorable to the non-moving party, i.e. the 14-year-old and his mother, viewing all the facts as favorable as possible in their favor, we still find that as a matter of law, they have failed to state a claim upon which relief may be granted. Therefore, case dismissed.
In other words, what the judge is saying is, even if everything the plaintiff said is true, there's no juror in the world that would grant them relief. And I have to believe that's wrong in this case.
That's wild.
I think any parent who sends a child to school for one purpose and finds out another purpose has been accomplished would have a right to feel outraged. And in a regime where my consent is necessary to interfere with my child's bodily integrity, you're damn straight I'd be angry about it, and I'd be claiming a liberty interest had been violated. The state action question interests me a great deal as well. While Old North County Medical, whatever it is, may be a private entity, it was intertwined with the state when it went to a state facility, and participants in a state-sponsored program were summoned there for one purpose, and its actors, the actors of the society, converted that to another purpose while on state property, and for purposes of accomplishing a goal that was foreign, as it were, to the private parties, but consistent with some state policy.
And that was interesting to me, Norm, because especially on the battery claim, the judge said that because the plaintiff failed to assert a theory of vicarious liability by and through, that it would fail as a matter of law, which again is just sort of doing some gymnastics to dismiss the suit in a way. I don't know.
Yeah, I don't know who the judge is, but every now and then you get a situation where you think the judge is determined to arrive at a certain outcome, law and facts be damned. So we'll keep an eye, and this certainly looks like it in this case. We'll keep an eye on this suit as it goes up. Our office had a loss yesterday we didn't expect to lose in the 8th Circuit Court of Appeals out of St. Paul, Minnesota. We brought a case on behalf of Mr. Sawyer and his wife, Mrs. Sawyer. They wanted to take ivermectin, and they found a physician who would prescribe it for them for use of treating their COVID symptoms. A Walmart pharmacist refused to fill the prescription because of corporate policy, spoke to the doctor, knew that it was a legitimate prescription that the doctor had made, and failed to honor it. We sued in federal court in what's called diversity jurisdiction, claiming that because they were, we went to federal court rather than state court, which may have been a mistake, because what happened is the federal district judge said that there was no right to bodily integrity. There was no fundamental right to bodily integrity under Minnesota law, and he dismissed the claim. We asked him to refer the matter to the Minnesota Supreme Court, because we think as a matter of common law there is, or there could be, and this is something the Minnesota Supreme Court should decide, not the federal court. He declined to do so. We argued the case earlier this summer in Minnesota. I felt pretty good. I felt the argument went pretty well. Yesterday, we got a 3-judge panel decision basically saying the court did not abuse its discretion by refusing to send the matter to the Minnesota Supreme Court because there was no indication that there was such a tort in Minnesota. That begged the larger question, and the larger question is who should decide Minnesota law, the Minnesota Supreme Court or federal appellate judges sitting in diversity? The fact that there is no extant or current claim or case directly on point begs the larger question whether the common law should be developed in such a way that the courts recognize this claim, because the Sawyers justifiably feel that a corporation violated the sacrosanct pact between they and their physician. The physician made a medical judgment about ivermectin. Walmart said no. So score a victory for corporate medicine in that case, and score a defeat for the rights of individuals to be treated in the way their physicians recommend. So we're in the middle of preparing what's called a motion for rehearing and reargument. One of the interesting things that we learned in the Minnesota argument is that the judges couldn't find a case in which the Eighth Circuit had ever asked the Minnesota Supreme Court to decide an issue of Minnesota law. I pointed out that it happens a lot in the Second Circuit, most notably in a case of mine involving Yale, where we got a decisive victory by the Connecticut Supreme Court when the Second Circuit asked for its interpretation of a matter of state law, and the response by the Minnesota court was, well, they like it in the Second Circuit, we don't like it here. So the question we will present on a motion for rehearing is whether the Eighth Circuit has abdicated its responsibility to seek guidance from state law courts on undecided questions of state law, and whether its failure ever to certify reflects a failure of nerve, frankly, and a failure of integrity, and such that the matter should be referred to the Minnesota Supreme Court. So I'll keep you posted on that as time goes on.
Sucks when the procedural aspects of a case really overshadow the substantive merit thereof, and it seems like in both of these cases that seems to be sort of the issue. I'm reminded that this guy is 14. And I remember the days when I was a rising freshman going into high school football. And this is a guy that has to have his mother or his stepfather drop him off places still, right? He hasn't even taken his first class of his freshman year. This is a kid. I call him a guy. This is a kid. And I think that there's a huge oversight on the judge's part to just use whatever procedural mechanisms are available. And what troubles me is that even if they are successful on appeal, Norm, you and I know that just sends this case right back down to where it originated, right?
But in terms of developing body of law, I mean, the COVID aftershocks will continue to rattle through the court for a number of years, and they're important because of what they tell us precedentially about what will happen in the next so-called public health crisis. And the real issue is do we want individuals retaining right to make fundamental decisions about how they should live and perhaps die? And do we want those rights to extend to their family with respect to children? Or do we want to yield the authority to make these decisions to the public and to public authorities? Because after all, the state knows best. And you can tell from the way that I frame the question where my passions are, because I don't think the state does know best. The state is an artifice, and it often gets it wrong. And even when it gets it right, we should have the right to decide we'd like to be wrong if that's what suits us.
Well, and certainly any truth to the assertion that that a decision maker, we can. Well, you say it much more eloquently than me, but I don't have a lot of faith in whomever the person is working a free clinic at a high school on a Saturday morning, right? Whose analysis of being unable to secure consent as required by law is to say, give it.
Just give it to him anyhow. Yeah.
So I mean those are the raw facts of this. A 14-year-old kid dropped off. He wants to play high school football. He's doing what he's required to do to get tested, and ends up getting vaccinated because somebody said, "Oh, just give it to him anyway."
Yeah, no, I hear you. It's shocking. Such is the world we live in. As the Wicked Witch of the West said in a memorable confrontation with Dorothy, "What a world, what a world. Oh, what a world."
Well, we are live every morning, 8 a.m. Eastern. If you're watching now, please make sure you have put a thumbs up on the video, that you have subscribed to Law and Legitimacy wherever you're finding us, whether you're on YouTube Live, whether you're on X, or whether you are on Rumble Video. We're here every morning, 8 a.m. Eastern, Monday through Friday. And all of our streams are uploaded immediately after the stream to Apple Podcasts, Spotify, Google Play, Audible, Overcast, etc. So if you're there, leave us a nice review, leave us 5 stars, or leave us alone. Norm, you look relaxed today. I'm liking that.
Yeah, I am. I'm going to seed. I'm up here. I mean, we had a lot of rain in Vermont last night. Shuddering to think whether the long dirt road we're at the end of is still there this morning, but that'll be a problem for after breakfast.
Photography asks, will your early followers get a percentage when you make it to the top? Look, we're open for proposals, but that presupposes, I'll take the compliment that you think we're going to make it to the top. Photography, I appreciate that. You have to talk to the big man now. 10% for the big man. He's sitting there in the Red Wings gear.
Oh yeah, something like that. The top. Hey man, I'm surprised we're still here every morning. Photography. Thanks for listening, and spread the word. We're here. Whether there's a top or not, who knows? But we've got opinions, and you've got thoughtful questions. Bring them to us, and let's get it on again tomorrow. Thanks for listening, folks.
Photography says you should. Thank you very much for that compliment. And like Norm says, we'll see you tomorrow morning. Thank you everybody for being here. Make sure you share the stream. Norm, I'll see you tomorrow.
Ciao.
Bye.